Hey guys, it's Joel Williams and Chase Elleby at Williams Elleby coming to you today with video number 5 out of our video series of 52 weeks of personal injury. What we want to talk about today is how to deal with delay tactics from insurance companies as well as defense attorneys. So we'll just kick it to Chase to start with. How do you like to deal with delay tactics from defense attorneys specifically?
Squeaky wheel gets the grease has kind of been my motto, right? You know, all defense attorneys have more than one case. That's not my case. So really, it's just a matter of picking up the phone, calling, sending emails, things like that. So a lot of things, having been a defense attorney for a few years, about 3 years, a lot of things that defense attorneys have to deal with are out of their hands, meaning they have their clients or insurance adjusters and things like that that they're dealing with that oftentimes aren't responsive to their requests and things like that. I like to give most defense attorneys the benefit of the doubt that they really are trying to do everything they can to move the cases along. So it's just a matter of me really just pestering them, emailing, calling, and just trying to make sure that my case gets the attention that it deserves, and just being consistent that way. So.
Yeah, I think the same mindset applies to insurance adjusters.
Right.
But it's not quite as bad, at least in my experience with insurance adjusters, because insurance adjusters almost universally prefer to try to get a case settled quickly and cheaply.
Right.
And they know just from statistics and data that the quicker they can get it settled, usually the cheaper they can get it settled if somebody's willing to take the quick dollar, right?
Right.
Defense attorneys is a little bit different. They, like you said, they have a whole lot going on, but they also have a interest in protecting their client, right? And the most common time that I see insurance defense lawyers engage in delay tactics is during the discovery process.
Sure.
Right? So during discovery, which is a time period after a lawsuit's been filed, where parties exchange documents, we exchange information, we take depositions and all of that kind of stuff. We usually don't like to take depositions until we have all of the documents and information that we need. Now, in more complicated cases that are very document intensive, where we may need business records or we may need financial documents or some kind of internal record that the only person in the world that has possession of that is the defendant, right? You'll get all kinds of objections and responses to your discovery that says, we're looking for it, we'll produce it, we'll supplement it, or it's work product, or it's attorney-client privilege, and everything else under the sun. So sometimes it's the actual lawyer, I think, that's trying to hide information that may be damning to his or her client. Other times, I think it's the client who is not giving the lawyer all of the documents and information that has been requested. Now, the lawyer doesn't get a pass there because
Sure.
It's the lawyer's duty to push his or her client to give up those documents if they're actually discoverable.
Or to find out where the documents are and that lawyer themselves go and actually look for the documents and do the searching instead of relying on the clients, which happens a lot of times. And as we know with lawsuits, most people don't want anything to do with them, especially companies or corporations or individuals that are being sued. So when a defense lawyer says, hey, John Smith, I need you to go and pull all these emails. Well, unless that, person's knocking on their door, John Smith isn't going to be too happy to pull all those emails, kind of stick their head in the sand and hope it all goes away. So.
Yep, that's exactly right. And then that's where the duty as the plaintiff's lawyer comes into play. You can't just send out these discovery requests and hope that you'll get everything you need and say, oh, great, they responded. If you're suspicious that they're withholding something, you have a duty to push it. And at least in Georgia, you have to have what we call a Rule 6.4, good faith discovery conference, basically where you call the lawyer up, you write a letter, say, hey, we think you're withholding this stuff. If you're not withholding anything, please confirm that nothing exists, and all of that kind of stuff. And then if that doesn't work, then you really have to go to the court and file what we call a motion to compel. And in the motion to compel, you tell the court what the issues are, and you ask the court to order the other side to give you those documents. And unfortunately, a lot of times, you won't get those documents until you file the motion to compel. So it's really important when you run into those delay tactics, I think, during the discovery process, to be diligent and always be professional, but also be persistent. Kind of the squeaky wheel analogy that you
Right.
said, but there's a there's the squeaky wheel of making phone calls, and there's the squeaky wheel of getting the court involved. And sometimes it comes to that level. So attorneys particularly need to, not be hesitant or afraid to ask for relief from the court when it's necessary.
Right, and also too, let's like in a hypothetical. Let's say the documents actually don't exist, but we can't tell, that we don't know based on what the other side's telling us as to whether or not they do or don't exist. Right. So a lot of times going through those motions, filing motions with the court, and just getting a definitive answer one way or the other, either they exist or they don't exist. And sometimes there not being documents is just as helpful to a case as there being a bunch of documents that haven't been produced. So, but kind of going back to the underlying issue about how you press them and things like that, it's our duty as the plaintiff's lawyers to push the case along and try to get past those hurdles. And sometimes it can be extremely frustrating because there's a lot of things are out of our hands. And all we can really do is just push the case as quickly and as efficiently as we can to trial, which is ultimately where we get justice for our clients.
Yeah. And before we get to trial, usually during the discovery process, we like to take depositions. The courts prefer and sometimes require us to coordinate depositions, which a deposition is basically just sworn testimony during the discovery process prior to going to court. So it's just like testifying in court, except for there's only the lawyers and a court reporter there, and whoever the witness is going to give testimony on a particular issue or subject. But the courts like us to coordinate those deposition schedules to make sure all attorneys are available for it. So oftentimes we'll send an email or a letter to the defense lawyer and say, hey, we'd like to depose, Johnny Smith. Please give us some dates that you're available for Johnny's deposition. And we'll get deposition dates 4 months out.
Or no response at all.
Or no response, right.
All right.
So in those situations, how do you handle that, Jess?
I just go ahead and notice the depositions, right? So a lot of times it's kind of like my, hey, squeaky wheel, I'm going to go ahead and notice the deposition, set it for this date, and that usually gets confirmation that the date's available, or I get a response email or a phone call, or one of my paralegals gets a call saying, hey, that date doesn't work, but we can be available this date or this date. So that's really, again, it's kind of, you want to handle things as cordially, I guess, as you can outside of the court, but sometimes when things aren't getting done, you have to just file the notice or put, get it in front of the court and have it, done that way. So
yeah. And then also ultimately, from a claimant or plaintiff's perspective, we always want to move the case as quickly as possible. And by moving the case as quickly as possible, I mean gathering all of the information we need in discovery and pushing towards trial. Because in order, at least in my experience, in order to get the best possible settlement in a case, the other side has to know that you're ready, willing, and able to try the case. So you're always pushing for that trial date. Unfortunately, nowadays, especially with the COVID pandemic and other things going on, trials are already delayed a good bit, right? Attorneys have backlogs in their cases, and all the oldest cases get priority over the newly filed cases. So what are some suggestions that you have for a case that's everything's been done, all the discovery's been done, mediation's been done, and you're basically waiting to get a trial date? Like, what do you do? Well,
if I don't have a trial date and the court's just kind of letting us handle things, I'll file a stipulation, basically letting the court know, hey, we're ready, go ahead and put us on the trial calendar. And then the court will, usually send out a notice saying, hey, I'll put you on the next available trial calendar. Y'all get together and put together what's called a consolidated pretrial order, which is basically the playbook for that trial. And that usually gets their attention, gets the defense attorney's attention, the adjuster's attention, like, okay, this case is getting ready to go to trial. Where are we at? What needs to be done? Is this something that can get resolved? And if not, then you'll be ready for trial. A lot of, another option too is just either stipulate to the trial calendar or send them an offer of judgment or some other demand to kind of put more pressure on the other side to get them to really pay attention to the case. But I'm sure we'll go into demands and things like that at another date. But that's just another way to sort of move the case along and get the responses that you wouldn't normally get. So
yeah. So I think to sum it all up, as far as dealing with delays from insurance companies and their defense lawyers, the main thing is to be persistent, always be professional. But if you have to, do not be afraid to get the court involved, because all you can do is be that squeaky wheel, but the court has the power to enter orders requiring the other side to do things. So if it comes to that, don't be afraid to do it, but always be professional in the manner in which you do it.
Yeah.
Got anything else?
No, I think we covered it.
All right. So we appreciate you watching this video. If it's been helpful to you, we appreciate you subscribing to our channel, liking the video, putting any comments in the section below where maybe if you're an attorney or someone who's dealt with delay tactics from insurance companies, things that have worked for you, just put it in there so it might be helpful to other people. Otherwise, we will see you next week for video number 6.